Mr. President, these wonderful people that you see around me, they represent the hundreds upon hundreds of surgeons, doctors, nurses, medical technicians, and hospital executives who were involved in several federal lawsuits across this nation, whose lawsuits have now revealed a very dark and sinister plot by select members of the federal judiciary to overthrow our republic, for the explicit purpose of installing the World Health Organization as America's de facto governing authority. My name is Brian Ward, and I was brought on as an expert consultant in these cases because of my knowledge of the biomedical research industry and how that industry intersects the fundamental 14th Amendment rights of the American people to absolutely refuse the injection of investigational drugs and/or participation in clinical trials and clinical investigations without incurring a penalty or losing a benefit to which they were otherwise entitled as promised to them by valid acts of the United States Congress. Now, I want to briefly talk about two topics to you today that have become national emergencies requiring your immediate intervention. The first is what President Joe Biden did in January in 2024 when his FDA enacted a regulation that the agency never proposed and promised in the Federal Register never to enact. This regulation, 21 CFR 50.22, specifically paragraph C. This regulation, for the first time in the biomedical research industry, allows sponsors of clinical investigations to conduct such investigations onto the American people without obtaining their legally effective informed consent or informing them that they're involved in such an investigation before, during, or after the study, even if injury occurs. Now, a clinical investigation is when the sponsor is going to expose humans to experimental drugs, biologics, devices, and other testing articles to study how those articles impact human anatomy. In my opinion, this regulation represents the single greatest assault on America's liberties in our nation's history. Now, specifically, here's what the regulation does. It allows the sponsor to obtain the identifiable private information, means that they know who we are, of the subject while covertly involving them in a biomedical research experiment. Because this fact is true, it now means, Mr. President, literally, that these sponsors can co-sponsor with an entity to conduct such investigations through our public schools on our children, through our universities on college students, through our doctors on patients, through hospitals. Worse still, it permits what's called targeted population studies, aka mass population. The FDA literally said under Joe Biden that because obtaining the legally effective informed consent of all the individuals in a mass population study is impractical, that the sponsor can waive the due process rights of all of those individuals because it's difficult on the sponsor to go out and get all of their consent. I just cannot describe to you the thousands of ways that this regulation violates the Constitution, whether it's a violation of our privacy, a violation of our due process rights not to be touched by other members of society in an offensive manner. It's a violation of the Takings Clause. It's a violation of the 13th Amendment involuntary servitude because now for-profit companies can conscript humans into laborious biomedical research experiments without their knowledge and extract their labor for free. This is absurd. Scariest still is that this regulation permits the creation of secret medical files that would be shared with unknown persons, unknown reasons for unknown length of time. For example, when a parent goes to a hospital and they give birth to a newborn, the blood is typically drawn. Well, underneath this regulation, now that blood can be sent off to what's called secondary research, the DNA extracted, sequenced, and attached to a secret medical file on that child that will follow them for the rest of their lives. This regulation needs to be vacated. It needs to be investigated. We need to have an understanding of the human rights atrocities that are already occurring in our nation. And there should be a criminal investigation into the people who added this language that the FDA never proposed into this regulation for the explicit purpose of robbing the American people of their fundamental constitutional rights. Therefore, I request that you put me in the same room with FDA Commissioner Marty McCary and HHS Secretary Robert F. Kennedy Jr. so I can bring him up to speed on this regulation. the history of it, and the laws that, the federal laws that it's violating right now, and with recommendations of how they can move forward to resolve this for America's benefit. The second topic that I want to discuss with you are these federal lawsuits, and they require the immediate intervention of the executive branch to protect significant interests of the United States government and the fundamental rights of all Americans. These lawsuits are COVID vaccine 19 mandate lawsuits, but they're unlike any lawsuits that have been filed to date. The reason is because it was indisputably proved that the defendants in these cases could not have issued mandates relying on such drugs and issued under such legal conditions. Now, some of the defendants include wonderful people such as Gavin Newsom of California, Mayor Bass of Los Angeles City, Hilda Solis of Los Angeles County. They acted only under ultra-vires authority, and I'm going to prove that to you in a moment when they issued their mandates. Now, to help you to understand how all COVID vaccine mandates in America from 2021 through 2023 were virtually unlawful as applied, I need to give you a quick history lesson of the phrase, quote unquote, legally effective informed consent. In 1972, the American people woke up to the human rights atrocity known as the Tuskegee experiment. Because of that, in 1973, Senator Edward Kennedy conducted hearings in the Senate exposing hundreds of similar research abuses that took place in America, harming untold hundreds of thousands of Americans, physically and economically. So, in 1974, Congress enacted a National Research Act. This act led to the creation of 42 U.S.C. Section 289. This statute, Mr. President, places the executive branch under a ministerial obligation to ensure that the rights of the American people are protected when they are involved in investigational new drugs, biologics devices, or related research activities. This right is found in 45 CFR 46.116, and it is titled Legally Effective Informed Consent. Now, what does this mean? It means that when an individual is presented with an opportunity to participate, anytime they're presented with such an opportunity, they must never come under outside pressure such as coercion, undue influence, or unjustifiable pressures to participate, nor can they be punished for refusing. They cannot incur a penalty, nor can they lose a benefit to which they were otherwise entitled. This is a well-established doctrine within the $600 billion pharmaceutical industry. Because this fact is true, in the year 2000, HHS established a federal-wide assurance program to comply with its obligations. This program contractually binds every entity to the legally effective informed consent standard who will access federal funds or operate under federal authority when involving humans in such activities and such products. Now, why does this matter to these vaccine mandate lawsuits? Because, Mr. President, from 2021 through 2023, all COVID-19 vaccine mandates exclusively relied on drugs classified by the FDA as investigational. For example, Pfizer-BioNTech COVID-19 vaccine operates and has always operated under investigational new drug application 19736. If a drug vial is labeled as investigational, it requires the legally effective informed consent for its administration without exception, no matter how it's introduced into commerce under any federal statute, period. Now, the one thing I need you to understand about an investigational drug to help you understand the danger to society by mandating these is that you can hold up 5 different vials of the same type of labeled investigational drug and yet have 5 different formulations. The reason for this is because the pharmaceutical company is studying the effects of the variations of its formulation to see which one provides better safety and efficacy. And the American people cannot be required under coercive conditions to become guinea pigs with these pharmaceutical companies. To date, all U.S. states have a federal-wide assurance agreement, including 30,000 additional entities, which would include most major hospitals and universities. I made this statement to inform you that of the massive misinformation campaign deployed against the American people by a very radicalized Democrat Party for the explicit purpose of coercing them into injecting one of these investigational formulations into their bodies. Now, let me bullet point the myriad of ways that these COVID vaccine mandates violate a federal law that most Americans are not aware of. Number one, there were only about 16 governors in America who mandated these drugs one way or the other. They were all Democrat Party leaders. Now, these governors, when they issued their mandates, they violated the following laws and federal agreements. Number one, they violated a federal wide assurance contract. Number two, these drugs were only offered underneath emergency use authorization. If you go down to paragraph L of the EUA statute, it declares that the Secretary has no authority to require anybody to manufacture the product, administer the product, or to receive the product. Therefore, underneath the field preemption doctrine of the Supremacy Clause, if he's preempted or prohibited from issuing such mandates, so too are all other state actors in America. Number three, these drugs were listed as covered countermeasures underneath the PrEP Act. The PrEP Act has an express preemption clause. It literally says that no state or political subdivision can establish a legal requirement that conflicts with any requirement underneath the FDCA. Such requirement would include the option to refuse an investigational drug. And you must remember, Mr. President, that Congress places the HHS Secretary under a ministerial duty to ensure that all Americans are informed of their option to refuse and to ensure that they can effectively exercise it. Finally, we have a constitutional provision at stake here. The PrEP Act requires individuals to waive their due process rights to sue anybody if they're injured by the product or any activity casually connected to it. The Supreme Court has held since our Constitution was written that no state may require an individual to waive their constitutional protections. The Supreme Court has repeatedly declared that states may not accomplish a result indirectly that they cannot command directly. So Gavin Newsom cannot command individuals, healthcare workers, to surrender their due process rights. Therefore, he cannot command them to participate in a PrEP Act countermeasure to achieve that result indirectly. To date, 31 federal judges have been presented with the facts that I just presented to you here today, Mr. President, and yet they dismissed these cases under Rule 12b-6 against state actors. Now, how can they do this without allowing a single fact to go through discovery? That's because they stripped all of these allegations from plaintiffs' complaints. They refused to acknowledge their existence or rule or give effect to valid acts of the U.S. Congress, valid acts of the executive branch, and they declared, the Ninth Circuit, the Fifth Circuit, the Third, the Sixth, one way or the other, that government and hospital CEOs and private parties can issue mandates requiring Americans to inject investigational formulations to their bodies, require them to publicly disclose their private health information to unknown persons, unknown reasons, for an unknown length of time, and require them to surrender or waive their due process rights if they're injured by the drugs or activities casually connected to it. Now, why would they be so egregious, engage in such misconduct, when it's a matter of court record that they're doing so? Well, a little birdie landed on my shoulder to explain to me what's going on, and I think it's pertinent here today, Mr. President. If you look at the new Governors Health Alliance, established by 15 Democrat governors, under the guise of fighting back against Secretary Kennedy's lawlessness, according to them, in effect, though, this alliance was established for the explicit purpose of seizing power from the federal government and to arrogate that power unto themselves and to any other third party who desires to issue a mandate involving unlicensed medical products for the purpose of creating a backdoor entrance for the World Health Organization. Let's look at two state laws that were recently enacted to help us to understand this fact to be true. Washington State enacted a law providing the state's health agency, stating that the agency can issue a standing health order for any drug, biologic, or device. Any is the key word, to include unlicensed drugs or unlicensed uses of licensed drugs. Then they said that they owe no duty to anyone when they issue an order. Now, what did they just do? They just eviscerated the Food, Drug, and Cosmetic Act. The entire FDCA Act stands upon the first sentence that says no person may introduce into commerce drugs not approved by the FDA. So they have claimed and seized power unto themselves unconstitutionally. Now we go over to the state of Illinois and you'll see where it really comes to light here. Illinois, under Governor Pritzker, just passed a law that says, literally, that if the FDA does not approve a drug, but the World Health Organization recommends it, then we can issue a public health order for that drug and it will not be considered an act of misbranding. Now, misbranding is a felony. Now, misbranding is when a person promotes a drug outside of its legally indicated indication as approved by the FDA as applied to its labeling. So what Illinois is saying is that hey, doctors, you can administer these drugs, cities, you can mandate these drugs, you can give it a legal indication according to the World Health Organization, even though it's not approved by the FDA, and we, the state, will not consider it to be a misbranding felony. However, it's still a felony under federal law. That's the one that really counts. Now, how did the courts come into play here? Well, the courts ruled that these governors had a rational basis because, listen to this, the scientific community thought or believed that these drugs were safe and effective. Not the FDA, not HHS, not the CDC, but because of scientific community. So what they're establishing is a legal precedent, a principle, that if the World Health Organization will act as the scientific community and it declares that the drug be safe and effective, that now these governors who have been granted this authority by federal courts, seizing power by the federal government and arrogating those powers to these persons, that they have a rational basis to mandate the use of these drugs during declared emergencies or any, in the state of Washington, any health concern, not just an emergency. So they're going further. Now, Mr. President, there's far more that can be explained in this video to you here today, but I hope I have given you enough information to help you to understand that these topics warrants the immediate intervention of the executive branch in these federal lawsuits because of significant interests of the federal government involved and the fundamental rights of the American people. So I request that you put me into a meeting with Secretary Robert F. Kennedy Jr. so I can bring him and his staff members through these legal conditions, these regulations, these international treaties that exist, and federal contracts to bring them up to speed onto them so they'll have a quality understanding of how to proceed for the specific purpose of protecting the health and safety of the American people and their fundamental rights. Thank you for listening to this recording. God bless you, and I hope to hear from you very soon.